Hi, my dear students. I am welcoming you to the corporate administration classes. Here we are discussing the concept in the second unit, that is what we call as formation of companies. In the formation of the companies, here we are already completing so many concepts regarding the second unit. Among those, once again, we are recalling about the concepts of the formation of the company. Here in this, we are completing the formation of company. In this, after that, the promotion stage. In the promotion stage, we are discussing about the meaning of promotion, definition of promotion, and steps what we have to be involving in the promotion of the company. After that, we are giving the meaning about the promoters and the definition of the promoters, legal position or the legal status of the promoters. After that, the most important concept is the functions of the promoter. Then now we have to be moving on the liabilities of promoters. The liabilities of promoter is nothing but it is very important concept. We called it as the responsibilities of the promoters. Responsibilities is very essential. Why? Because each and every stages, each and every steps is involved by the promoters only. Promoters taking the each and every activities of the promoting of the organization. Therefore, promoter plays an important role in the formation of the company, where the promoter of a company enjoy some rights as well as they incurred some liabilities. This is what we called as liabilities of promoters. Liabilities of promoters. ಅದನ್ನು ನಾವು ಕನ್ನಡದಲ್ಲಿ ಪ್ರವರ್ತಕರ ಹೊಣೆಗಾರಿಕೆಗಳು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕರಿತೀವಿ. ಪ್ರವರ್ತಕರ ಹೊಣೆಗಾರಿಕೆಗಳು. ಹೊಣೆಗಾರಿಕೆಗಳು ಅಂತ ಹೇಳಿದ್ರೆ ಜವಾಬ್ದಾರಿಗಳು. ಪ್ರತಿಯೊಬ್ಬ ಪ್ರವರ್ತಕನು ಸಹ ಕಂಪನಿಯಲ್ಲಿ ಅತ್ಯವಶ್ಯಕವಾದಂತಹ ಪ್ರಧಾನವಾದ ಪಾತ್ರವನ್ನು ವಹಿಸ್ತಾ ಹೋಗ್ತಾನೆ. ಯಾವ ರೀತಿಯಾಗಿ ಅವನಿಗೆ ಹಕ್ಕುಗಳಿರುತ್ತೋ ಹಕ್ಕುಗಳ ಜೊತೆಯಲ್ಲಿ ಅವನಿಗೆ ಅವನದೇ ಆದಂತಹ ಹೊಣೆಗಾರಿಕೆಗಳು ಮತ್ತು ಅವನದೇ ಆದಂತಹ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಸಹ ಅವನು ಹೊಂದಿರ್ತಾನೆ. ಹೀಗಾಗಿ ದ ಫಸ್ಟ್ ಒನ್ ಈಸ್ liability in respect of completion of a contract. Liability in respect of completion of the contract. This is the first liability of the promoter. This is the first liability of the promoter. Here, liability in respect of completion of contract. What it means, the contract? Contract is nothing but it is a agreement. Contract is nothing but it is a agreement. So what type of agreement it is? What type of agreement it is? Either it is a finance agreement or it is a legal agreement. It is very important. We should know that there. So contract is nothing but agreement. Contract is nothing but agreement. So agreement, what type of agreement it is? A contract is nothing but it is an agreement made between the two parties. Made between the two parties. Who are those two parties here? Promoter and the company. Promoter and the company. So in the promoter and the company, we made a contract. That what type of contract it is? It is a promotion contract. Each and every incorporating activities is performed by the promoter. This type of contract we are made in respect of the company's promotion. Therefore, this is the first liability in respect of, in favor of, he must and should complete the contract. He must and should complete the contract. Contract is nothing but it is a agreement. The promotion of a company involves either the acquisition of an existing business or starting a new business. Or starting a new business. Or starting a new business. So this is what we called as liability. So here the first liability tells us the promoter must and should complete his activities of promotion, activities of the company. So therefore the agreement must and should be legally made. The agreement must and should be legally made. This legal agreement must and should be performed by the ಪ್ರಮೋಟರ್ ಓನ್ಲಿ. ಪ್ರವರ್ತಕ ಏನ್ ಮಾಡ್ಬೇಕಾಗಿರುತ್ತೆ? ಸೊ ಅವನ ಒಂದು ಜವಾಬ್ದಾರಿ ಆ ಒಂದು ಜವಾಬ್ದಾರಿ ಅಂತ ಹೇಳಿದ್ರೆ, ನೋಂದಣಿ ಪೂರ್ವ ಒಪ್ಪಂದಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತಹ ಜವಾಬ್ದಾರಿಗಳು. ನೋಂದಣಿ ಪೂರ್ವ ಒಪ್ಪಂದದ ಜವಾಬ್ದಾರಿಗಳು ಏನೇನಾಗಿರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಕಂಪನಿ ನೋಂದಣಿಗೆ ಒಳಪಡಿಸುವಂತಹ ಒಂದು ಮೊದಲು ಕಂಪನಿಯು ಹಲವಾರು ಒಂದು ಒಪ್ಪಂದಗಳಿಗೆ ಪ್ರವರ್ತಕರ ಜೊತೆ ಒಂದು ಸಂವಹನ ಮಾಡಿರುತ್ತೆ. ಆ ಒಂದು ಎಲ್ಲಾ ಒಪ್ಪಂದಗಳನ್ನು ಸಹ ಇಲ್ಲಿ ಆ ಒಬ್ಬ ಪ್ರವರ್ತಕ ಆಗಿರ್ತಕ್ಕಂಥವನು ದೃಢಪಡಿಸ್ಬೇಕಾಗಿರುತ್ತೆ. ಎರಡನೇದೇನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ, ಪ್ರವರ್ತಕನು ಪರಿಚಯ ಪತ್ರಿಕೆಗಳಲ್ಲಿ ಏನೇನು ಹೇಳಿಕೆಗಳು ಕೊಟ್ಟಿರ್ತಾನೆ, ಯಾವ್ದ್ಯಾವ್ದಕ್ಕೆ ಜವಾಬ್ದಾರಿ ಆಗಿರ್ತಾನೆ, ಆ ಎಲ್ಲಾ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅವನು ನೆರವೇರಿಸಬೇಕಾಗಿರುತ್ತೆ. ಮತ್ತು ತಪ್ಪು ಹೇಳಿಕೆಗಳು ಏನಾದ್ರು ಕೊಟ್ರೆ ಅವನು ಕ್ರಿಮಿನಲ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವನಿಗೆ ದಂಡವನ್ನು ವಿಧಿಸ್ತೇವೆ. ಮತ್ತೆ ಅವನಿಗೆ ಏನ್ ಮಾಡ್ತಾ ಹೋಗ್ತಾವಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ, ಜೈಲಲ್ಲಿ ದಂಡ ವಿಧಿಸಿ ಅವನಿಗೆ ಜೈಲು ಶಿಕ್ಷೆಯನ್ನು ನೀಡತಕ್ಕಂತಹ ಸಾಧ್ಯತೆಗಳು ಜಾಸ್ತಿ ಇರುತ್ತೆ. ಹಾಗಾಗಿ ಅವನೇನ್ ಮಾಡ್ಬೇಕಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ, ಕಂಪನಿಯಲ್ಲಿ ಯಾವ ಎಲ್ಲ ಹೊಣೆಗಾರಿಕೆಗಳನ್ನು ಒಪ್ಕೊಂಡಿರ್ತಾನೆ, ಯಾವೆಲ್ಲ ಒಂದು ಒಪ್ಪಂದಗಳನ್ನು ಒಪ್ಕೊಂಡಿರ್ತಾನೆ, ಆ ಎಲ್ಲಾ ಒಪ್ಪಂದಗಳನ್ನು ನೆರವೇರಿಸಬೇಕಾಗತ್ತೆ. ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಒಪ್ಪಂದಗಳನ್ನ ಅವನು ನುಣುಚ್ಕೊಳ್ಳೋದಾಗಿರ್ಲಿ, ಸುಳ್ಳು ಮಾಹಿತಿ ಕೊಡೋದಾಗಿರ್ಲಿ, ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಒಪ್ಪಂದಗಳಿಂದ ತಪ್ಪಿಸ್ಕೊಳ್ತಕ್ಕಂತಹ ಒಂದು ವ್ಯವಹಾರ ಮಾಡಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅವನಿಗೆ 2 ವರ್ಷ ಕ್ರಿಮಿನಲ್ ಜೈಲು ಶಿಕ್ಷೆ, 5,000 ರೂಪಾಯಿಗಳ ದಂಡವನ್ನ ನಾವು ವಿಧಿಸ್ತೀವಿ. ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಇದು ಮೊದಲನೆಯ ಒಂದು ಹೊಣೆಗಾರಿಕೆ ಅಥವಾ ಜವಾಬ್ದಾರಿ. The first one is the liability in respect of completion of the contract. Contract is nothing but agreement. So in the promotion of a company, it involves the acquisition of an existing business. Each and every business is started. So to complete the activities, it is a contract made between the two parties. Who are those two parties? Promoters and the company. Who are those two parties? Promoters and the company. It is very, very essential to complete each and every activity of the promoter. So therefore, why? Because in a pre-acquisition situation, in a pre-contract situation, before enter into the contract, so many agreements here is going to sign it. So in that situation, so what are the each and every important concepts, topics they are agreeing, they are understanding, each and every conditions must and should satisfy, activities must and should perform by the promoter. This is the first liability of the promoter. It is the first responsibility of the promoter. After that, the second one here. After that, the second one here, liability due to fiduciary relationship. Fiduciary is nothing but it is a trustee relationship, third party relationship. A promoter must and should has a fiduciary relationship with the company based on trust and confidence, which entails two main liabilities for the promoters. Why? Because he's not an agent of the company, he's not a trustee of the company, but on behalf of the companies, he act as a trustee and he act as a trustee and confidential person on behalf of the company. So therefore, it is very, very essential. We must and should perform the each and every liability of the promoters. What are those two liabilities on behalf of the fiduciary relationship? On behalf of the fiduciary relationship, andre fiduciary relationship ಅನ್ನು ಹೊಂದಿರೋದ್ರಿಂದ, ಕಂಪನಿ ಫಿಡ್ಯೂಷಿಯರಿ ರಿಲೇಶನ್ಶಿಪ್ ಅನ್ನು ಹೊಂದಿರೋದ್ರಿಂದ ಏನಪ್ಪಾ ಇಲ್ಲಿ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಅಂತ ಹೇಳಿದ್ರೆ, ಕಂಪನಿ ಫಿಡ್ಯೂಷಿಯರಿ ರಿಲೇಶನ್ಶಿಪ್ ಅನ್ನು ಹೊಂದಿರೋದ್ರಿಂದ ಕಂಪನಿ ಯಾವುದೇ ಒಬ್ಬ ಪ್ರವರ್ತಕನು ಯಾವುದೇ ಒಬ್ಬ ಪ್ರವರ್ತಕನು ಇಲ್ಲಿ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ ಕಂಪನಿಯ ಪ್ರತಿನಿಧಿನೂ ಆಗಿರೋದಲ್ಲ, ಧರ್ಮದರ್ಶಿನೂ ಸಹ ಆಗಿರೋದಿಲ್ಲ. ಆದ್ರೆ ಕಂಪನಿಯ ಪ್ರತಿನಿಧಿಯಾಗಿನೂ ಸಹ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತಾನೆ, ಧರ್ಮದರ್ಶಿಯಾಗಿನೂ ಸಹ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತಾನೆ. ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಮಾಹಿತಿಯನ್ನ ಇಲ್ಲಿ ಅವನು ಕೊಡ್ತಾ ಇದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಕಂಪನಿ ಆ ಒಂದು ಪ್ರವರ್ತಕನು, ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಕಂಪನಿಯ ಪರವಾಗಿ ಪ್ರವರ್ತಕ ಏನ್ ಮಾಡಿರ್ತಾನೆ, ಎಲ್ಲೋ ಒಂದು ಒಪ್ಪಂದಗಳನ್ನ ಮಾಡ್ಕೊಂಡಿರ್ತಾನೆ. ಅಂತಹ ಒಪ್ಪಂದಗಳು ಮಾಡ್ಕೊಂಡಂತ ಸಂದರ್ಭದಲ್ಲಿ ದ ಪ್ರಮೋಟರ್ ಮಸ್ಟ್ ಅಂಡ್ and should. See, there is the two important liabilities or responsibilities of the promoter. Two important liabilities or responsibilities of the promoter here. The first one is, if the promoter has made any secret profit in a capability of a promoter, he must and should return those profits. This is the first and basic important responsibility or liability of the promoter. If any secret profits is earning, why? Because if any secret, we don't know when we are establishing the organization, each and every assets and liabilities, each and every properties belonging to the company. So it is handled or maintained by the promoter only. In that situation, if they has the power to use each and every properties of the company, they made or we don't know. So they are earning certain sum of profits. That is called as a secret profit. They can't disclose any other persons. They can't show any other persons. In that situation, this type of secret profits also promoter must and should return to the company. Why? Because it is totally company profit. It is totally company profit. If any secret profit is earned by the promoter, he must and should provide or return to the company only. This is the first. In the second point, the first sub point, it is the first sub responsibility of promoter. And the second one, if he has made any secret profit by selling his personal property to the company. See, this is the second responsibility. If he has earned any secret property by selling his personal properties, means company's personal properties, he must and should liable to the company's property, and to solve or to provide or to repayment of the company's properties, he must and should sell his own property, then settle down the company's profits. This too is very, very essential responsibilities of the company promoter. After that, the second one, ಮಾಹಿತಿಯನ್ನ ಬಹಿರಂಗಗೊಳಿಸಲು ವಿಫಲನಾದಾಗ ಪ್ರವರ್ತಕನ ಹೊಣೆಗಾರಿಕೆಗಳು ಏನೇನು ಅಂದ್ರೆ, ಮಾಹಿತಿಯನ್ನ ಬಹಿರಂಗಪಡಿಸಲು ಅಂತ ಹೇಳಿದ್ರೆ ಅವನು ಧರ್ಮದರ್ಶಿಯಾಗಿ ಮತ್ತು ಅವನು ಆ ಕಂಪನಿಯ ಪ್ರತಿನಿಧಿಯಾಗಿ ಅವನು ಯಾವುದೇ ಒಂದು ಒಪ್ಪಂದ ಮಾಡ್ಕೊಂಡಿರ್ತಕ್ಕಂಥ ಎಲ್ಲಾ ಒಂದು ವಿವರಗಳನ್ನ, ಸಂಪೂರ್ಣ ವಿವರಗಳನ್ನ ಅವನು ಕೊಡೋದ್ರಲ್ಲಿ ಏನಾದ್ರೂ ಅವನು ವಿಫಲನಾದ್ರೆ, ಅಂದ್ರೆ ಕೊಡಕ್ಕಾಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಕಂಪನಿ ಅವನ ಜೊತೆ ಇರ್ತಕ್ಕಂಥ ಒಂದು ಒಪ್ಪಂದವನ್ನ ರದ್ದುಗೊಳಿಸುತ್ತೆ. ಮತ್ತು ಕಂಪನಿಯಲ್ಲಿ ಅವನೇನಾದ್ರೂ ರಹಸ್ಯ ಅಥವಾ ಗುಪ್ತ ಒಂದು ಲಾಭಗಳನ್ನ ಗಳಿಸ್ಕೊಂಡಿದ್ರೆ ಆ ಲಾಭಗಳನ್ನು ಸಹ ಕಂಪನಿಗೆ ಪುನಃ ವಾಪಸ್ಸು ಕೊಡಬೇಕಾಗಿರುತ್ತೆ. ಇದು ಎರಡನೇ ಒಂದು ಹೊಣೆಗಾರಿಕೆ ಆಗಿರುತ್ತೆ. ಆಫ್ಟರ್ ದಟ್ ದ ಥರ್ಡ್ ಒನ್ ಈಸ್ Third one is liability in case of fraud or breach of duty. This is also one of the most important liability of the promoters. What happens here? See, in this situation, in case of the company is put to a loss because of an act of fraud or mistake or misrepresentation or breach of the contract or breach of the duty on the part of the promoters, the latter shall compensate the company such loss and is liable to be sued for damages of the company. So this is the third most important liability of the promoter. So here any frauds or breach of duty is nothing but breach means breakdown. Breach means breakdown. Breach is nothing but breakdown of the duty. He is not performing the duty. So this is what we called as breakdown or breach of the duty. So in this situation, company is going to cancel the contract with the promoter. Company is going to cancel the contract with the promoter if any severe damages, if any major losses is occurred because of the promoter. So company going to complain Company going to complaint against the promoter. So this is the third responsibility. He can't do any fraud or any duty we are assigning to him is he must and should complete. If any damages is done by on the activities or the breach or breakdown of the duty, so then he is punishable. Then he is punishable. This is the third most important responsibility. He doesn't make any fraud, he doesn't make any mistake, or he don't has performed their duties and responsibility. It a mandatory compulsorily he must and should perform the liability. He must and should perform his duties or activities. ಅಂದ್ರೆ ಅವನು ಮೂರನೇದ್ರಲ್ಲಿ ಏನು ಹೇಳ್ತಾನಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ, ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ವಂಚನೆ, ಫ್ರಾಡ್ ಇನ್ ಕನ್ನಡದಲ್ಲಿ ನಾವು ಹೇಳ್ಬೇಕಂದ್ರೆ ವಂಚನೆಗೆ ತುತ್ತಾದಂತ ಸಂದರ್ಭದಲ್ಲಿ ಕಂಪನಿಗಳ ಕಾನೂನಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ, ಪ್ರವರ್ತಕ ಏನಾದ್ರೂ ವಂಚನೆ ಮಾಡಿದ್ರೆ, ಮೋಸ ಮಾಡಿದ್ರೆ, ಆಗ ಅವನಿಗೆ ನ್ಯಾಯಾಲಯದಿಂದ ತಪಾಸಣೆಗೆ ಅವನ ಮೇಲೆ ನಾವು ದೂರನ್ನು ದಾಖಲಿಸಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಾವು ದಾವೆಯನ್ನ ಹೂಡಿ ಅವನ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನು ಕೊಟ್ಟು ನಾವು ಅವನಿಂದ ನಮ್ಗೆ ಎಷ್ಟು ನಷ್ಟ ಆಗಿರುತ್ತೋ ಅಷ್ಟು ನಷ್ಟವನ್ನ ನಾವು ಅವನು ಪಡ್ಕೋಬಹುದು, ಕಂಪನಿ ಪಡ್ಕೋಬಹುದಾಗಿದೆ. ಸೊ ಇದು ಮೂರನೆಯ ಒಂದು ಜವಾಬ್ದಾರಿ. ಅವನು ತನಗೆ ವಹಿಸಿದಂತಹ ಎಲ್ಲಾ ಕೆಲಸಗಳನ್ನು ಸಮರ್ಪಕವಾಗಿ ಸಂಪನ್ಮೂಲಗಳನ್ನ ಬಳಸ್ಕೊಂಡು ಅವನು ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಜೊತೆಯಲ್ಲಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಮೋಸ ವಂಚನೆಯನ್ನ ಇಲ್ಲಿ ಮಾಡಬಾರ್ದು. ಸೊ ದಿಸ್ ಈಸ್ ಅಬೌಟ್ ದಿ ಥರ್ಡ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ, ಮೂರನೆಯ ಹೊಣೆಗಾರಿಕೆ. ನಾಲ್ಕನೇದಕ್ಕೆ ಬರೋಣ. ಅಂಡ್ ದ ಫೋರ್ತ್ ಒನ್ ಹಿಯರ್, see in the fourth one, liability on death of promoter. So we don't know what happened in a particular situation. So what they are telling us here, death of a promoter. Why? Because each and every situation, promoter, if he is mentally capable, physically strengthened, we don't have any problems. But what happens here, because of the promoter's death, he is having any health problems, what is our situation? If a promoter who has made inappropriate use of his position for personal profit, he dies, such profit can be claimed by his property or estate. See what they are telling. So in between the contract, if we are continuing the contract, in between the contract, the promoter is going to dead. In that situation, each and every promoter must and should they pay the company's profits or the company's amounts by selling his own property or estate. By selling his own property or estate. So this is what we call as the another liability of the promoter. Maybe if his death means we don't have any profit, we don't have any profits, it is loss for our company. In that situation, the company is going to recovering the profits, this company is going to recovering the losses. Those losses is recovered by selling own property or own estate of the promoter. Why? Because he is a person, when he dies, because of him we getting the losses. So therefore, he is held liable, the person is held responsible person, he must and should repay the company's losses. This is also another liability of the promoter. ಅಂದ್ರೆ ಪ್ರವರ್ತಕ ಏನಾದ್ರೂ ತನ್ನ ಜವಾಬ್ದಾರಿಯನ್ನ ನಿಭಾಯಿಸದೆ ಅವನು ನಿಧನ ಆಗ್ತಾ ಇದ್ದಾನೆ, ಸುತ್ತು ಹೋಗ್ತಾ ಇದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಆ ಸತ್ತು ಹೋಗುವಂತ ಸಂದರ್ಭದಲ್ಲಿ ಏನಾಗತ್ತಪ್ಪ ಅಂದ್ರೆ, ಪ್ರವರ್ತಕನು ಅಕಸ್ಮಾತ್ ಏನಾದ್ರೂ ಸತ್ತು ಹೋದ್ರೆ ಅವನ ಹೊಣೆಗಾರಿಕೆ ಅನ್ನುವಂಥದ್ದು ಮುಗಿಯೋದಿಲ್ಲ, ಅವನ ಜವಾಬ್ದಾರಿ ಅನ್ನುವಂಥದ್ದು ಅಲ್ಲಿಗೆ ಕಂಪ್ಲೀಟ್ ಆಗಲ್ಲ. ಅವನು ಏನ್ ಮಾಡ್ಬೇಕು, ಅವನ ಆಸ್ತಿಗಳನ್ನ ಮಾರಾಟ ಮಾಡಿ ಕಂಪನಿಯ ಒಂದು ನಷ್ಟವನ್ನ ಅವನು ತುಂಬಿಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಕಂಪನಿಯ ಒಂದು ನಷ್ಟವನ್ನ ತುಂಬಿಕೊಡ್ಬೇಕು. ಯಾಕಂದ್ರೆ ಅವನು ಸತ್ತೋಗಿದ್ರು ಸಹ ಕಂಪನಿ ತನ್ನ ಪ್ರವರ್ತನೆಯ ಒಂದು ಚಟುವಟಿಕೆಗಳನ್ನ ನಿಲ್ಲಿಸೋದಕ್ಕಾಗೋದಿಲ್ಲ. ಸೊ ಆ ಸಂದರ್ಭದಿಂದ ಏನ್ ಮಾಡ್ತಾರೆ, ಎಲ್ಲಾ ಒಂದು ಚಟುವಟಿಕೆಗಳು ನಿರಂತರವಾಗಿ ನಡೆಯೋದ್ರಿಂದ ಇಲ್ಲಿ ಪ್ರವರ್ತಕ ಏನ್ ಮಾಡ್ತಾನೆ, ಸತ್ತೋದ್ರೂ ಸಹ ಅವನ ಚರ ಅಥವಾ ಸ್ಥಿರ ಆಸ್ತಿಗಳನ್ನ ಮಾರಾಟ ಮಾಡಿ ಅವನು ಏನ್ ಮಾಡ್ಬೇಕಾಗಿರುತ್ತೆ, ಕಂಪನಿಗೆ ಅವನ ಒಂದು ನಷ್ಟವನ್ನ ತುಂಬಿಕೊಡ್ಬೇಕಾಗಿರುತ್ತೆ. So this is the another liability of the promoter. After that, the fifth one here. After that, the fifth one here, liability for misstatement in prospectus. Liability for misstatement in prospectus. What they are telling here, misstatement in prospectus. Prospectus, what it means? Prospectus is nothing but it is a detailed information regarding the company. It is a book or it is a statement of detailed information of the company. But what happens here? Misstatement. Misstatement is nothing but misrepresentation. Who given this misrepresentation? Promoter given this misrepresentation. Because of the misstatement made by the promoter in the prospectus, we getting the losses. If the shareholder suffers any loss because of the statutory mistake, here statutory mistake is nothing but statutory mistake. Statutory mistake is nothing but legal mistake. Statutory mistake is nothing but legal mistake. Statutory mistake is nothing but legal mistake. Is any legal mistake is done by the promoter in the prospectus, and it is estimated that the mistake or because of the negligency or carelessness or misconduct on the part of the promoter, so he is held responsible for this damage. Therefore, the company is claiming each and every amount or losses for the promoters negligences because of the promoters carelessness. So therefore we having the losses because of shareholder getting the losses. So therefore it is also one of the responsibility of the promoter. He gives the a clear statement in the prospectus, so each and every shareholder, they doesn't get any losses when we are given the correct statement in the prospectus. After that, the next responsibility is liability on insolvency. Liability on insolvency. Here, what they are telling us, liability on insolvency is nothing but if a promoter become insolvent. What it means? Insolvent is nothing but unable to pay. Insolvency is nothing but unable to pay, is incapable to pay. His property shall be liable for his debt. What it means? The debt. Debt is nothing but debt of the company. So here, debt. If a promoter becomes insolvent, his property shall be liable for his debt. ಅವನು ತಗೊಂಡಿರ್ತಕ್ಕಂಥ ಸಾಲಕ್ಕೆ, ಅವನು ಮಾಡಿರ್ತಕ್ಕಂಥ ಒಂದು ಸಾಲಕ್ಕೆ, ಕಂಪನಿ ಜೊತೆ ಅವನೇನಾದ್ರೂ ಸಾಲ ಮಾಡಿದ್ರೆ ಆ ಒಂದು ಸಾಲಕ್ಕೆ ಅವನೇ ಹೊಣೆಗಾರಿಕೆ ಆಗ್ತಾನೆ. ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಸೊ ಇದು ಜವಾಬ್ದಾರಿ ಏನ್ ಹೇಳ್ತಪ್ಪ, ಈ ಒಂದು ಹೊಣೆಗಾರಿಕೆ ಏನ್ ಹೇಳ್ತಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ, ಯಾವುದೇ ಒಂದು ಲಾಭವನ್ನ ಇಲ್ಲಿ ಕಂಪನಿ ಅಥವಾ ನಷ್ಟವನ್ನ ಇಲ್ಲಿ ಕಂಪನಿ ಪಡ್ಕೊಳ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಈ ಪ್ರವರ್ತಕ ಏನಾದ್ರೂ ಒಂದು ಸಾಲಗಳನ್ನ ಮಾಡಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಅವನು ಆ ಸಾಲಗಳನ್ನು ತೀರಿಸ್ಲಿಕ್ಕಾಗಿ ಅವನ ಒಂದು ಓನ್ ಪ್ರಾಪರ್ಟಿ ಏನಿರುತ್ತೆ, ಸ್ವಂತ ಚರ ಮತ್ತು ಸ್ಥಿರ ಆಸ್ತಿಗಳೇನಿರುತ್ತೆ, ಅದನ್ನ ಮಾರಾಟ ಮಾಡಿ ಅವನು ಆ ಒಂದು ನಷ್ಟವನ್ನ ಸರಿತೂಗಿಸ್ಕೊಡ್ಬೇಕಾಗಿರುತ್ತೆ. ಇಟ್ ಈಸ್ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಇಫ್ he is unable to pay his debts, he must and should sell his own properties, own buildings, own lands. He must and should sell each and every his properties. So each and every property is selling by solving the debts of the promoter. So after that, the seventh one here, Yes. After that, the seventh one here, liability for the loss of assets for which no account is given. Here, what happens here? Liability for the loss of asset, any loss we are incurred because of the asset for which no account is given. No account is given is nothing but if the promoter purchase any asset without giving an account of the purchase, if he is purchasing the account of machinery, if he is purchasing the furniture, each and every purchasing details is must and should given to the company. So therefore, purchase or purchase returns, each and every information must and should provide to the company. It is very, very essential. So each and every person must and should give the information regarding the purchase or sales. After that, the eighth one here, liability on winding up of the company. At the winding up of the company, winding up is nothing but close of company. Winding up is nothing but close of the company. So here, when he is closing the company, at the winding up of a company, any person who has participated in the company's promotion, each and every company's promotion is involves. If the company is closing, so in that closing situation, any guilty or misfeasance is held by the promoter. The promoter must and should give the right information when the closing of the company. ಅಂದ್ರೆ ಕಂಪನಿ ಏನಾದರೂ ಕ್ಲೋಸ್ ಮಾಡುವಂತ ಸಂದರ್ಭದಲ್ಲಿ, ಕಂಪನಿಯನ್ನ ನಾವು ಮುಚ್ಚುವಂತ ಸಂದರ್ಭದಲ್ಲಿ ಕಂಪನಿ ಪ್ರತಿಯೊಂದು ಮಾಹಿತಿಯನ್ನು ಸಹ ಇಲ್ಲಿ ಪ್ರೊವೈಡ್ ಮಾಡಬೇಕಾಗಿರುತ್ತೆ. ಸೊ ದಿಸ್ ಇಸ್ ಅಬೌಟ್ ದಿ ಲಯಬಿಲಿಟೀಸ್ ಆಫ್ the promoter. So what are those liabilities of the promoter? The first one is liability in respect of completion of contract, and the second one is liability due to fiduciary relationship. Third one is liability in case of fraud or breach of duty, and fourth one is liability on the death of promoter, and fifth one is liability for misstatement in prospectors. Sixth one is liability on insolvency. Seventh one is liability for the loss of assets for which no account is given. Means if they are purchasing but they are not showing in the profit and loss account and balance sheet, means it is very, very essential, it is a loss to the organization. In that situation, he must and should responsible for the loss of the company. He must and should give the information regarding purchase or sale. And the eighth one tells us the liability of winding up is nothing but if we are closing the company, in that situation, each and every activities information progress we are given. So it is essential to give each and every information of the reports must and should given to the top level management. So this is very, very important according to the law, according to the Companies Act of 2013. So what they are prescribing, each and every rules and regulations must and should satisfied by the promoter. These are all what we called as liabilities of promoters.